Court does call the case of Affinity Investments and Technology versus Willie Cater.
Good morning, Your Honor. Ron Ruark for the plaintiff, Affinity.
Good morning, Your Honor. Willie Cater.
Where are we on this case?
Your Honor, we were here 2 weeks ago. At that point, I think it was the 15th or so, Mr. Cater indicated he had deposited a check. He did deposit that check, but it bounced. On the original possession judgment, he still owes $4,780. There's an additional $6,300 owed for April, May, and June rent. He owes over $11,000. I'm asking the court to reinstate the order of eviction with an effective date today, so that my client can reclaim this property and pay their mortgage.
Cater, anything you want to say? Mr. Cater?
He's muted, Your Honor.
Can you hear me, Your Honor?
I can hear you now.
All right. First of all, good morning, Your Honor. And what Mr. Ruark said is partially true. I deposit the $5,000. Well, it was two payments that got deposited. I deposited $2,100 in money orders, and then my sister had wrote me a check for $38.80, and I didn't even know that the check didn't come back until Wednesday, until I talked to Miss Linda, which is my landlord, who texted me Wednesday morning and did on the 28th and told me that the check had came back. Didn't know anything about it. Immediately called my sister, asked what was going on. She said she'll call and see, Your Honor. I don't know what's going on with that, but I did deposit $2,100 and money orders that I got from Walmart, and my sister had wrote me that $3,880 something. I thought everything was all good until I got the text message early Wednesday morning, which was on the 28th, 2 days ago, and told me that it had came back. And I responded to her and told her, well, I don't know how much my check is this week, but I found out my check is $1,256. I did not know this check came back. I've been trying to keep up with these payments. On this single father, I work every day. I pay him every week. And it's just unfortunate that I'm not going to say it's my sister's fault. It's just unfortunate that it did come back, which I thought I was good, because the money that I'm supposed to deposit, I'm going to deposit tomorrow, I'd have been all caught up. But $3,880 of that, Your Honor, had came back. Other than that, I'd have been on point, Your Honor. So on the original, what Mr. Warwick talking about, the numbers are wrong with him, because I do the numbers well. And I've talked to the client. She's the one I've been to communicate with. So none of this, what he's talking about, never came up to me. Only thing she asked me to do from here on out, she said, and her exact words were, "It never happened to you. It never happened to you before. So just from now on, just put a cashier's check, a money order in there." And
well,
that's
sir,
all.
Sir, you were supposed to tender to them the $6,800 that didn't get tendered.
Yes, sir.
To them.
Yes, sir. I mean,
So
it got partially tendered to them, which, Your Honor, I'm a hard worker, single father.
I
you understand what I'm saying? I'm a hard worker, single father, Your Honor.
Mr. Cater, I don't doubt any of that. But at some point, yes, the funds have to be there. It's got to be paid.
And Your Honor, listen to me. I wish I would have knew. I had a 2-day notice of this, that it came back. Like, I could have deposited my check last week and this one and caught the $38.80. You know, I didn't know that this check didn't come back until 2 days ago. And you know, when you hear something like that, it's like, wow, when you think you know, it's like you've been defeated, because it's like I'm going forward, I'm getting caught up. But dang, I'm bouncing back now. Like, you know, I've never had no problem with Mr. Ward or my client like this. But, you know, I make good money, Your Honor. I pay them every week.
Then maybe you can work something out with them regarding this writ. But in terms of your motion to set aside the judgment, the motion to set aside is denied. The writ may issue.
Your Honor, should I submit a new writ?
All right,
Yes, sir.
Can I
'Cause
ask
I'll submit a new writ, Your Honor. Thank you very much.
I would like to know, how much time is this new, or Your Honor, or how much do I have to pay to stop this writ? Is it the 3880 that has
I
to
think
get in
there's
there?
about
Because that's
four-
all.
Mr. Cairo.
No, I only owe $3,880, Your Honor. Yes, sir.
I'm gonna wait for you to stop interrupting. Are you done?
Yes, sir.
Counsel, you indicated there's about 4,000 something on the judgment, correct?
4,780, Your Honor.
Okay. That's the amount.
That number is wrong, Your Honor. That number is wrong, Your Honor. It is. Oh yes, I'm sorry. That number is right. And how much is owed on it, Your Honor? Again.
Counsel, give him the number again.
$4,780 is owed on the original possession judgment. There's of course.
All right.
Another...
Thank you. Thank you so much for that. $4,080. Okay, Your Honor. And I just want to ask you so I can get an understanding.
Court calls the case of Abil Aguilar or Guiar Aguilar versus Michelle Dart.
Man, that's why you got to bring that.
Good morning.
Good morning, Your Honor. Matthew Kuiper is on behalf of the plaintiff.
All right. Where are we on this? I had last time the balance was going to be paid.
Your Honor, so it looks like the defendant did pay $1,450 of the $1,677.52 that was owed, which leaves a balance owed of $227.52.
All right. And Ms. Dart, what do you have to say to that?
Your Honor, I was paid today, and I went to 7-Eleven this morning, and I paid next month's rent, and the $200 fee, making a total of $860.
All right, counsel, you don't have that one, correct? You don't.
I don't, Your Honor, and what I'm happy to do is, if the court would allow, we do a conditional dismissal. As long as that payment goes through, the case will remain dismissed.
Ma'am, will that work for you?
Yep.
Okay. So what we will do is we'll do a conditional dismissal of this case, and I'll indicate order to follow. Ma'am, once that conditional dismissal comes in and you signed it, you'll have 3 business days to think about that conditional order. If for any reason you believe that there's some right you haven't asserted or some confusion on your part, you would have to file a motion within those 3 business days before this court. You understand that, ma'am?
Yep.
Okay, very good. I'll await the order.
That form that I need to sign, or is that going to be through my landlord? Or I guess, is that through the court system?
Counsel, how do you intend on getting it to her?
We'll contact the landlord and get it to her through the landlord.
Okay, that's all I need to know.
Thank you.
Thanks, Judge.
Court calls the case. Andre Gilbert versus Marcus Hollis.
Good morning, Your Honor.
Your name?
Andre Gilbert.
Sorry, Mr.
Right.
Gilbert. Dan Shemke appearing on behalf of the plaintiff, Judge.
All right. Marcus Hollis. Is he here?
Yes, sir.
Oh, there he is. Okay, got it. All right. Where are we on this, folks?
Judge, last time around, you determined that we had filed the wrong complaint.
Yes.
We refiled a complaint for non-payment of rent, served it on the defendant. You had also ordered us to produce the ledger. That
Yes,
was attached to the complaint together with another copy of the lease. And all of that went to the defendant, and now we're back here asking for entry of a judgment, which I just realized we had not submitted to you.
yes,
So
that is correct. All right.
I propose.
And go ahead.
We haven't received any payments from the defendant, so I propose to move forward on entry of the judgment,
All right.
which will
Mr.
follow.
Anything you want to say on this?
Yeah, I'm gonna be making a payment real soon. That'll cover the whole thing.
The whole thing?
Yes, sir.
When you say real soon, when is that?
I would say in the next 2.5 weeks, I should be all the way caught up.
Okay, well, all right. Well, that's not going to quite work because then you're going to have July. You're going to pay that too?
I'll probably still owe July, but I'll be caught up.
All right. Well, here's what I'm going to do. This is probably your advantage, actually. I'm going to grant judgment to the plaintiff for possession. What is your total amount that's owed, including costs, sir?
You're asking me or my client, Judge?
I'm asking either of you, whoever can tell me.
All right, I can tell you there is, as of today, $3,950 in rent due, plus an additional $199.96 in unpaid utility charges, for a total amount today of $4,149.96. Of course, tomorrow there will be an additional $1,800 added to that amount, for a total, by the time I send my judgment into you and you enter it, the total, unless he pays in full today, will be $5,949.96.
Well, I'm entering the judgment today. That's what you wanted me to do. So I'm only going to go on what's due today. So judgment to the plaintiff, redemption amount $41.49.96, with a writ to issue in 10 days. Court finding no tribal issue.
I have a question, sir.
Thank you. Yes.
Thank you very much, Judge.
What's your question, Mr. Hollis?
I was never served any papers with no amount, and that amount is still off, and that's not the real amount.
What do you mean you were never served any papers?
I was never served any papers. No papers were ever brought to me between the last court date and now. I have nothing regarding anything.
Judge,
any other papers were brought straight to me and were served directly to me, and nothing was served to me, sir.
Judge, those papers were served by mail, Mr. Hollis having appeared at the last hearing.
Yes. Okay. All right. Thank you.
Judge.
Mutual Rose Community Management versus Shirley Ramsey. This is the one, right?
Yes, and they are on it. You can see them.
She can see him?
Yes.
Okay.
Good morning again, Carrie Zanin, P67390 on behalf of plaintiff standing in for counsel of record.
Ms. Ramsey, can you unmute and then state your name? Okay, we're gonna send somebody in there. Just hold on a moment, Ms. Ramsey. We're sending somebody in to help you out.
I was the one that was here last Friday, so I understand, Judge.
Yeah,
Well, I couldn't do math about 2 minutes ago, so I can't talk.
You sending Ellen?
I did.
Okay.
Yeah.
Mr. Ramsey, I'll call your case back up in just a moment. Let me do somebody else, do some other cases, and then we'll do that. Is there closed caption on?
The closed caption is on. I was told she can see it. And I think she's down there reading.
Okay.
Oh, she's unmuted now.
Okay, you're unmuted. Ms. Ramsey, can you hear me?
Yes.
All right. Okay. Where are we on this case? Counsel, you're muted.
Woo, good thing I'm in person at 3:30. This is a health hazard, Your Honor, for excessive clutter, hoarding, fire hazard. And this is the first time we're before you. So last week we were before the magistrate. I do remember Ms. Ramsey mentioning something about an attorney. I'm not sure if that was, I got an attorney. I'm looking to get an attorney because there was some technical difficulties as well last time.
Ms. Ramsey, did you speak to legal services?
I did. They came and they looked at my apartment and they said that they're not going to represent me because this is not a serious case and that they had other people that needed them more. So that's it. I'm here by myself.
Okay.
I also have my manager here, Judge. I'm confused by that, but
Okay, and is it clutter or what are we?
Judge, I have Miss Johnson online. I would like her to maybe unmute. I have a bunch of pictures as well. Judge, it is a lot of clutter, but I think it became a fire hazard, and I think that's the dilemma. Miss Johnson, can you unmute?
Can you hear me?
Yes.
Yes, I can hear you now.
Ms. Johnson, am I describing the situation correctly, or do you have anything else you want to tell the judge?
Yeah, I mean, that's basically it. I went and inspected the apartment yesterday and you just cannot move around. She said there were some things that were going to be removed to like last night after the office closed and after I was there and saw it probably about 3 o'clock, and that she was still working on it. But it's just, there's so much that it's just really difficult. You can't even move around in the apartment very much.
Miss Ramsey, are you going to get someone to help you move the things?
I had a statement from my practitioner who explained that the problem was that I had been having back spasms and that slowed me down. And I do have my niece. My niece came last night and we took some things out. The only things that are sitting around are, as I explained to Miss Johnson, is that I was clearing things out, going through cupboards and so on. And so I boxed things up to sort. And that's what's sitting there, is things to sort and get rid of. And but the health issue has impeded that. So that's basically it. And it's not that I'm unwilling or that I don't know what I'm doing or what I want to do. I have a program, an agenda. It's just that my physical circumstances have slowed it down. So that's the state I'm at now. Is simply a matter of having enough time to finish the process. I have done this for other people in the building, several other people. I go in and I assess and I organize and I set up 3 categories, one for throw away, one for donate, and one for keep. And the keep is usually a plastic bin, so there's no cardboard or paper left around. And I also, for the last 4 years, I have been looking after 3 of my neighbors, trying to help them to be able to stay in their apartments. One of whom, there were gnats flying around in the hall, and he happened to say something about gnats coming out of his kitchen sink drain. So I went and bought all the supplies, and I came with my rubber gloves and my spray on Clorox gel that sticks to things. And I scrubbed out his garbage disposal to end the gnat problem.
Okay, all right, so Miss Ramsey,
Yes,
within the next week, you said you had packed a number of things in boxes, right?
well, I lumped them in the box, and those are things that
Okay.
have to be determined where they go and what happens.
All right.
to them. And
So
that's
can
it.
those things that you packed in a box, can you get them out within the next week?
I would think so.
You think you can?
Beg pardon?
You think that you can do that?
In a week, I can, yes, I can do some of that. I can get rid of the boxes.
Okay. So let's do this. I'm gonna end things in boxes to be removed. And then what I'm gonna do is I'll adjourn this matter to July 7th, 2023 at 9 a.m. Okay?
Okay, yes.
Thank you, Judge.
I have pictures on my phone of my kitchen, my pantry, my storage closet with all my cleaning supplies, which will show you how I organize and how organized I am. The only thing hindering me, as I said, was a physical impairment.
I understand. All right. Let's see what we can get done in a week. Okay, ma'am?
Okay, thank you. I appreciate it. And
Thank
Ms.
you.
Johnson also, thank you.
SNC Holdings LLC versus James Smith Jr.
Morning, Your Honor. Tracy Thomas appearing on behalf of the plaintiff. Mr. Smith, you're on
Mr.
mute.
Smith?
There you go.
Okay.
Yes, I'm here, Your Honor.
All right. And this is a termination case?
It is, Your Honor.
All right. And?
Your Honor, there's not, last time we were in front of the magistrate, Mr. Smith indicated that he was making arrangements to move out. He's been on a month-to-month since May of 2019.
Mr. Smith, where are you on moving out?
Your Honor, I can't really do anything until tomorrow till I get my VA check. And then as far as renting a truck, and it's just me moving. I'm trying to ask for 10 days to get all this stuff out. I'm not, I don't have any help to move this stuff out. So,
all right. You're a veteran? What branch?
Army, sir.
There might be some services through the VA that can help you a little bit. Counsel, what I'm going to do is, so do you think you can be out in 10 days, correct?
Yes, sir.
All right. So rather than put a judgment against him, counsel, I'm going to adjourn this out a week. Let's see if he can get most of his stuff out and move someplace and get himself on his way. All right.
Your Honor, as a suggestion, maybe adjourn it 2 weeks.
Yeah, okay, that's fine. As long as there's no objection.
And if we get word that he's out, then neither one of us need to appear in 2 weeks.
That's good. Okay, you got that, sir?
So you're adjourning it 2 weeks from today?
Yes, to the 14th, July 14th.
Okay.
9 is 9 in? at 9 a.m. And that'll give you your 10 days and a little bit more to get yourself out, okay? And as Mr. Thomas indicates, if everybody's moved out and they verified it, then you guys may not even have to be here next week. Or 2 weeks out. Got
Okay,
it?
sir. Yes, sir.
All right. Thank you.
Judge.
Thanks.
Gene Pelliccio Living Trust versus Casey Adkins.
Morning, Your Honor. Attorney Andrew Babnick on behalf of the trust.
Casey Adkins. There's no one here. This is termination.
It
Do you
is,
wish
Your
to
Honor.
proceed, counsel?
I do, Your Honor. We were here last week in front of the magistrate, at which time Ms. Atkins had said she was going to be speaking with legal aid. This is a termination case, forceful or peaceful possession with forceful retention. She is the daughter of the decedent. The decedent died back in January. The property is already in the trust. Trust certificate's been recorded with Washtenaw County. We've given her plenty of time here. There was a notice to quit that was served back on February 16th. We waited to file the eviction to give plenty of time here. So what we are asking the court at this point for the entry of the default, and if the court would entertain the issuance of the writ pursuant to 600.5744 subsection 3, an immediate issue of the writ, as we've pled that this is a result of forcible entry or peaceable entry held by force.
I think what I'll do, and counsel, raise your right hand, please. Do you swear or affirm everything that you said is true to the best of knowledge, information, and belief?
I do.
All right. What I will do is I will grant a judgment to the plaintiff for possession, no redemption amount. However, the writ will issue in 10 days. I'm gonna do it that way.
Understood, Your Honor. I'll prepare that. Your Honor, can those orders be submitted to your office via email?
No, you need to submit them to the clerk's office, please.
Clerk's office. All right, understood. Thank you, Your Honor. Appreciate the time.
Thank you. Court calls the case of Patrick Garabi versus Carlton Barber.
Hold on, there you go. Hello.
Hello,
Okay, I'm sorry, I'm doing.
Hello.
Talk to the.
I'm Patrick Garabi.
So it's a paper with proof of service. Yeah, I'm here, I'm so sorry, now I'm doing.
Last week, I was in front of the magistrate and he wanted proof of service. And he said that I could show it.
I need a copy in the court file.
I tell him it's a proof of service.
Yeah, it's a proof of service, they show me.
All right, sir, here's what I'm gonna do. You need to get a copy of that down to the court. The proof of service. It has to be filed. So I'll adjourn it out to the 7th, 9 a.m. And I'll indicate we need a proof of service in file.
You had to get it to the court.
Oh, I had to bring it to the court? Hold on 1 second. Yeah, I did that already. I brought it to the court, so I gotta bring it back to the court again?
You brought it to the court?
Yes, I did. So I had to bring it
When?
to the court. That was May 25th. May 25th. This is it right here.
Ma'am, I don't have the proof of service in my file.
Okay, so what do I need to do now?
Okay, you need to get a copy of that proof of service down to the court so they can put it in the file. I'm giving you a week to do that, and then we can proceed on this matter.
Okay, so where do we go from here? How much longer, how long would it take me before this case is taken care of?
Okay, I've adjourned it out 1 week.
Yes.
To the 7th at 9 a.m. I need the proof of service before I can do anything, and I don't have a copy of my file.
Before you make a judgment, okay,
Yes, ma'am.
okay.
All right.
Today.
Thank you. We'll see you next week.
Thank you so very much. Okay.
Lawrence Cairo versus Patrick Cox and Laura Cox.
Lawrence Carroll here.
Got either one.
Patrick and Laura Cox are here.
Yeah.
Okay.
We're here.
All right, this is a termination case. And where
Yes,
are
sir.
we on this?
Your Honor, I implore the court's wisdom of Solomon on this one. It's a really tough case. I will tell you up front that Laura has paid all of the payments. There is not a financial deficit except for the assessment for cleanup that the township put on it last year, but I had made arrangements with Laura to make those in equal monthly installments, and she is making those. However, since the last time the township went out to that property and cleaned it up and assessed my taxes, they put it on my tax bill, and I had to pay $15,000. And my escrow has increased my mortgage payment by $2,500 for the past assessment that the township put on as taxes, which was allowable by the court order. And they're anticipating that it's a tax, what's going to happen again. And I'm just losing my shirt right now on this. We went to court again on Tuesday, and another order was issued by 14A4 allowing the township to go back in and clean the property up because they gave them, and that was filed in February, and it's still not cleaned up. And she finally just said, township, go clean it up and assess the Coxes. Unfortunately, the order that the township has proposed to that judge would allow them once again to put that assessment on my taxes, which means I'm going to end up paying it, not the Coxes. So I'm imploring your words of wisdom. I can't get them to clean it up. The township can't get them to clean it up. The court can't get them to clean it up.
Mr. Cox, what do you want to say?
Yeah, this is Patrick Cox. What Larry's saying is largely true, but the reality is that we don't ever get it cleaned all the way up. So I think that I just want to say that, and meaning that it's not something that I'm just ignoring. It's something that I have struggled to get done within the time that was allotted, and I believed I had enough time, and I was just wrong. So the property is in much better shape than it was. I mean, to some people, they may say that it's not, but it's just not. It's just not seeing the property the way that I see it because I walk it, and so the majority of what was nearer the street remains. And so I think that it just kind of casts an ugly look over the rest of the place. But having said that,
so
the truth is that
how long did Judge Freshour give till the township's going to come in and clean it up?
She
essentially immediately, but the township, I'm sorry, Larry, I didn't mean to cut you off, but just that I don't think she put an actual time on it, Your Honor. I think she just said they have the authority to do that. And I did ask in court with the prosecutor how long that might be before they came, because I'm fully committed to them not coming.
And what did they tell you?
He said it might be. He said it'd probably be about 2 weeks because his the guy from the township is on vacation, so he won't even be back, and then attempt to schedule it for. I don't know the exact amount of time, but he thought it'd be 2 weeks.
Your Honor.
Yes, sir.
I did speak with Mr. Toth, who's the zoning administrator for York Township, and he did tell me that he has a July 10th date tentatively scheduled. Again, I have a motion before the court. I don't even know if I have standing, but I have a motion that I submitted before the court asking the court to prohibit the township from assessing my taxes and find a way to collect from the Coxes. I don't know if that will be successful. I don't know if I have standing, but if this is allowed to continue, I will lose that house.
All right, but that motion is not before me, is it?
No, it's before Judge Anna
Freshour.
Freshour, because she's the
Yes.
one that made the ruling, and she's the one that's going to approve the
Right,
language.
so when is that motion set?
It's not said. I haven't heard anything from her. Again, I don't even know if I have standing.
Okay, I don't. Got it. Okay, so here's
And
what
Your Honor-
here's what I'm gonna do. You realize you've got 10 days to do that, but the thing that I'm also gonna do in this case is I'm going to allow the plaintiff to amend the complaint to request damages. It's another thing in terms of getting paid. So what you'll have to do, sir, is you'll have to pay the difference in the filing fee for the damages.
Okay.
Portion of it, okay? And then I'm going to adjourn this out to the 14th. If it's not cleaned up and the township has done it, if you have a township bill, then I'm going to allow those as damages against the Cox in this matter.
Okay. I'm not sure I entirely understand it, but.
Okay,
but
so
I
here's the
agree with
bottom
it.
line to it. You guys are supposed to clean that property up. The property has to be cleaned up. The township, Judge Freshour has ordered that the township do it if you guys don't do it.
Correct.
And plaintiff in this case is saying, well, if the township comes in and does it, then I owe the money and you guys are supposed to pay it back when you're the ones that are supposed to be keeping it clean. So what I'm
Right.
saying is if you guys don't get the property cleaned up, I'm going to give a judgment, a monetary judgment, not only for the property, but a monetary judgment to the plaintiff for whatever the costs are in cleaning it up.
I understand. All right. That's more than fair.
Would this court entertain a motion prohibiting the township from assessing my taxes?
That is not my case. You'll have to bring that before Judge Freshour.
I appreciate it, Your Honor.
All righty. July 14th, 9 a.m. Thank you.
Thank you.
That
Thank you.
ends our 9 o'clock block. We'll get ourselves set up for the 10 o'clock. Court is standing brief recess.